And we are going to be looking at the process, actually, of the criminal justice system. And this section focuses on the adult system. So here we go. When an adult is arrested, he or she goes through a specific process. The process includes arraignment, indictment, trial, and sentencing or acquittal. So this is the information for that section. The criminal justice system faces a challenge. It must protect society against those who break the law. It must also protect the rights of people accused of crimes. Americans often disagree about how to balance these responsibilities. The arrest and pretrial process. In order to make sure that people's rights are protected, there are many steps that must be taken to decide whether a person is guilty of a crime. To follow those steps, suppose that Jack Jones broke into an electronics store and stole portable MP3 players. The arrest. Jack Jones enters the criminal justice system when he is arrested by a law enforcement official. To arrest Jack, the police must have probable cause. Probable cause is a good reason to believe that a suspect has been involved in a crime. If the police see Jack commit the crime, or if someone reports that Jack has committed the crime, then the police have probable cause to arrest him. A person can also be arrested if the police have a warrant for his or her arrest. A warrant is a legal paper issued by a court giving police permission to make an arrest, seizure, or search. To obtain a warrant, the police must give evidence to a judge. During the arrest, the officers must tell Jack that he has the constitutional right to remain silent and to have a lawyer present during the questioning. This is part of the Miranda warning. After the arrest, Jack is taken to a police station. The police record Jack's name, the time of the arrest, and the charges, or reason for the arrest. At this time, Jack has the right to make a phone call to a lawyer or to someone who can arrange for a lawyer. Then he is placed in a jail cell. The case is given to a prosecuting attorney or prosecutor. In the state court systems, the prosecutor will be the district attorney or DA or an attorney on the DA staff. The prosecutor will lead the government's case against Jack Jones. If the prosecutor decides that the case against Jack is too weak, the charges may be dropped and the suspect released. On the day of his arrest or soon after, Jack appears in a court for a preliminary hearing. The suspect, Jack Jones, is now called the defendant. At this hearing, the prosecutor must show the judge that a crime has been committed and that there is enough evidence against Jack to go ahead with the case. The judge may decide to dismiss the case if the prosecutor cannot show that there is enough evidence that Jack committed the crime. If the crime could lead to a prison sentence, Jack has a right to the help of a lawyer or an attorney. If he does not have enough money to pay for the lawyer, the court will appoint one at his hearing. The lawyer may be either a private attorney whom the government will pay to represent Jack or a public defender. Public defenders are lawyers who work full-time for the government defending criminal suspects who cannot afford to pay. The defender's lawyer is called the defense attorney. Gideon versus Wainwright. This was a Supreme Court case that took place back in the 1960s. And this is an important case. So I'm going to read it to you before we move on to the rest of the section. The case established that every person accused of a crime has a right to a lawyer. In 1961, Clarence Gideon, an unemployed 40-year-old man, was accused of breaking into a Florida pool room and was arrested. He asked the court for a lawyer, saying he had no money to hire one himself. The judge refused, saying that under Florida law, only people accused of a capital crime, a crime in which the death penalty was possible, could have a lawyer appointed by and paid by the court. Gideon claimed that under the Sixth Amendment, he was entitled to a lawyer, even though he could not afford to hire one. Gideon did his best in representing himself at the trial, but he was convicted and sentenced to 5 years in jail. From jail, Clarence Gideon wrote a letter in pencil to the United States Supreme Court appealing his conviction. The case reached the Supreme Court in 1963. The decision. The Supreme Court voted unanimously in favor of Gideon, saying that the Sixth Amendment did guarantee Gideon had the right to a lawyer. The court said, in denying Gideon the right to counsel, a lawyer, the state of Florida had denied him due process of law, a violation of his rights under the 14th Amendment. The court's decision overturned Gideon's conviction for burglary. Okay, so going on. In either a misdemeanor or felony case, the defendant may enter a plea of guilty, not guilty, or a plea of no contest at this first court hearing. In a no contest plea, a defendant does not admit committing the crime but accepts the punishment anyway. At this first appearance in court, the judge may set bail. Bail is money that a defendant gives the court as a kind of promise that he or she will return for the trial. If the defendant does not return, the court keeps the bail. The judge may also simply let the defendant go on his or her own reconnaissance. This means that the defendant is considered not to be a risk to society and likely to appear at the trial. If the judge decides the defendant is dangerous to society, the defendant can be held in jail without bail. The grand jury. The Constitution says that a grand jury must review cases involving serious federal crimes. Some states use grand juries too. The grand jury is a group of from 16 to 23 citizens. Its job is to decide whether there is probable cause for believing that the defendant committed the crime. The grand jury acts as a check on the government. It protects the rights of the individual, making sure there is enough evidence against him or her. The grand jury may either return an indictment, which means a formal charge against the accused, or refuse to indict. A defendant who is indicted must appear in court for a felony, arraignment. An arraignment is a court hearing in which the defendant is formally charged with a crime and enters a plea of guilty, not guilty, or no contest. If the defendant pleads guilty, no trial is needed. If the defendant pleads not guilty, the defense attorney will take the next step. Pretrial motions. If Jack Jones pleads not guilty to the charges against him, there are important steps called pretrial motions that may be taken before the actual trial begins. One of the most important motions is to keep evidence from being presented in court. Sometimes the defense attorney may say that the police obtained the evidence through an illegal search. If the judge rules that key evidence cannot be used in the trial for this reason, the prosecution may have to drop the charges. This rule protects the constitutional rights of the accused, but it may result in people who have actually broken the law being set free. Plea bargaining. Most criminal cases go to trial. The main reason these cases do not go to trial is that the defendant pleads guilty. A trial is not needed. If a defendant knows that he has broken the law and that the evidence against him is strong, he might want to make a deal with the prosecutor. Making such a deal is called plea bargaining, agreeing to plead guilty in exchange for a lesser charge or a lighter sentence. As a result of plea bargaining, the defendant gets a milder punishment than he or she would probably have received in a trial. Meanwhile, the government saves the cost of a trial. Going to trial. Suppose that after all these steps, Jack's case makes it to court. What happens in the courtroom? Jury selection. Citizens are called to serve on the jury. They are questioned either by attorneys on both sides of the case or by the judge. The purpose of the questioning is to determine who will consider the evidence carefully and then make a fair decision. Sometimes many people must be asked questions before a group of jurors would be selected. The trial. The rights granted by the Constitution determine how a trial is run. The trial must be speedy and public. The defendant, Jack, has the right to call witnesses and to question witnesses called by the prosecution. He has the right to be present in the courtroom, but he does not have to answer questions. The purpose of the trial is to decide whether Jack is innocent or guilty. Usually, statements made by witnesses are the most important evidence in a trial. A witness may be a person who saw the crime take place. A witness may also be the defendant, the victim, or anyone who knows anything about the defendant, the victim, or the crime. The attorneys in the trial each call their own witnesses, asking them questions in court. After one attorney questions a witness, the other attorney may question that same witness. At the end of the trial, the attorneys for each side make closing arguments. The judge then gives directions to the jury and sends it out to make its decision. A jury must decide whether the defendant is guilty beyond a reasonable doubt. If they have any doubts about the defendant's guilt, they must find the defendant not guilty. If the jury cannot agree, it is called a hung jury, and the case may be tried again before another jury. Sentencing. If Jack is found guilty or pleads guilty, the final step in the courtroom is sentencing. Sentencing is deciding how the defendant will be punished. The law generally sets a maximum and a minimum sentence for each crime. Sometimes the judge has the power to decide the length of the sentence within a certain range. The judge considers the severity of the crime and the criminal record, age, and attitude of the defendant. For example, the judge may give a first-time offender who regrets his crime a lower sentence. Sometimes, however, a judge may follow sentencing guidelines. These provide a narrower range of sentences based on the nature of the crime and the defendant's criminal history. However, if the defendant felt that a sentence was unfair, he or she could appeal the ruling. Correctional institutions. Having been convicted, Jack now enters the corrections system. He may be sentenced to a community treatment program, a jail, or a prison. Cities and counties run jails. They hold people waiting for trial. People convicted of misdemeanors may also serve time in jail. Both state and federal governments run prisons. People convicted of serious crimes such as murder and robbery are usually sent to prisons. In prison, they are called inmates. An inmate's time in prison may be reduced for good behavior. Letting an inmate go free to serve the rest of his or her sentence outside of prison is called parole. A group called a parole board decides whether to let inmates go before their sentences are over. In 2005, there were just over 1.5 million state and federal inmates and almost 750,000 inmates in local jails. Our society spends a large amount of money running jails and prisons. Challenges facing the system. Our criminal justice system is challenged by the number of people it may deal with each year. There were approximately 10 million arrests in the United States in 2004 and almost 10.4 million in 2005. In many courts, there are not enough judges and other court employees to handle all the people waiting for trial. In the last decade, nearly every state has increased the number of youth under 18 who are processed by adult criminal courts rather than juvenile courts. This growing population of young defendants and prisoners presents unique challenges to the entire criminal justice system. Lawyers, judges, probation officers, and corrections officials are encountering new problems and looking for guidance in how to deal with them. Prisons are also overcrowded. The number of people in prison nearly doubled between 1990 and 2001. New prison construction has not kept pace with the growing prison population. A 2005 Department of Justice report stated that some state prisons housed up to 14% more inmates than they were designed to hold. Federal prisons housed 34% beyond their capacities. Proposals for fighting crime. Because of public pressure, presidents, governors, and mayors have been giving top priority to fighting crime. These leaders have many ideas about how to solve our crime problem. However, few of them agree. What someone thinks is the best solution to crime depends on what he or she sees as the major cause of crime. Preventing crime. Many people think we should work harder at preventing crime. There are several ways to help prevent crimes, including neighborhood watch programs. Meanwhile, many people favor broader ways of preventing crime. They want to attack what they see as the root cause of crime, poverty, and other social problems. Being tougher on criminals. Others believe that the best way to fight crime is to be harder on criminals. Congress and some states have passed laws calling for mandatory sentences, punishments that are set by law and that a judge must give no matter who the defendant is or the reason for crime. In some states, for example, anyone who uses a gun while carrying out a crime must be sent to prison. Many people also favor the death penalty or capital punishment as a sentence for serious crimes such as murder. The death penalty, however, has many opponents. Some people point out that innocent people have been wrongly convicted of murder. They feel that the possibility that the government might execute an innocent person makes the death penalty unjust. The Supreme Court, however, has upheld state laws allowing the death penalty. Rehabilitation. Rehabilitation is the process of trying to teach inmates how to live productive lives when they are released. Unfortunately, rehabilitation is not working very well. A large number of inmates break laws again after they are released. Many people, however, say that rehabilitation programs can be improved and become an important way of fighting crime. Some rehabilitation programs take place within prison. Inmates may get counseling that helps them understand and change the way they behave. Educational and job training programs are also a part of inmate rehabilitation. Rehabilitation may continue after the inmate's time in prison is over. Some ex-prisoners live in halfway houses, group homes for people who are returning to life outside of prison. There, they get support and help. They can test new skills in a job that brings in a steady income. Some people believe that skills and job training can reduce the number of former inmates who commit crimes again.